let's get going. So welcome everybody to Problem Solving and Information and Resources. I'm Kerry Mahoney from the ARC of Massachusetts, and I'm going to be your host today. Today I am grateful to Karen Mariscal, who is an attorney that specializes in special needs practices. And she's going to be talking today about filing for guardianship and court procedures and how COVID has affected this during these times. So she's going to give us some hints on how to deal with the courts and that sort of thing. So welcome, Karen. It looks like we have a good mixture of family members, self-advocates, and professionals on the call. So
Great.
Welcome.
Great.
And I also should say that Karen is also a parent, and she is also part of our steering committee at the ARC of Massachusetts. So very happy to have you, Karen.
Thank you.
Thank you.
Yes. Hi, everybody. There's my son. He's intellectually disabled and autistic, and he just turned 28 on July 10th. And so I had to go through this guardianship procedure myself, and we live in Norfolk County, so that was the county that I did the procedure in. But I just want to talk about guardianship in general so everybody understands what the procedure is, no matter COVID or not. And then we'll talk about what's going on right now with COVID. And, that changes. We've had a new standing order every couple months. So we have June 24th or something, they came out, the Supreme Judicial Court came out with the latest standing order on how the courts are to proceed. And I expect another one as we continue to reopen. But yes, Monday, supposedly our probate courts were open, July 13th. And in fact, in practice, they weren't open to people in general. It was really the only people they're letting in is people that have evidentiary hearings or trials that can't do their business otherwise. So that really they're trying to continue. Fortunately, they've considered guardianship an emergency, whether it is or not. That's how the standing order is proceeding. So the courts are absolutely trying to proceed with guardianship matters. They're taking the filings and they're trying to hold the hearings. So I'll talk about that and the differences in some of the courts, because our probate courts are handling things differently. Middlesex is a very busy court. It has like 54 towns, and so it's handling things different than, for example, Norfolk. But anyway, let's get started. I see, Kerry, if you could move it along. It doesn't seem to move along for me. Not sure why. There we go. So let's start with the basics about guardianship. Why are we talking about this with you? Generally, if your child is less than 18 years old, 17 or under, you are by law their guardian. So you are making decisions for them on things like housing and medical and all that. By law, you don't have to do anything in particular. But upon their 18th birthday, under law, no matter who how this child looks or whatever, you're no longer their guardian. They're emancipated under the law and they can do what they want. So when we have children who aren't able to make their own decisions, they don't have capacity is the word we use, someone needs to go to court to get to be their guardian, and generally it's their parents. So my son, he doesn't speak, he doesn't understand the question you're asking him. So obviously he needs a voice. So when he turned 18, my husband went and got guardianship for him, and I'll talk about why it was my husband instead of me later. There are plenty of people in our world who don't need guardians. They can make their own decisions, and we don't recommend that you get guardianship over that group of people. And then there's some that are a little bit more in the middle, and you have to think it through with your clinician. Do we need to do, because you're taking some rights away from the person by becoming their guardian. Although you are required by statute to consult with them about everything. You can't just decide on your own without any input from them where they're going to live, or what school they're going to go to, or whether they should have this medical procedure. But sometimes it's a tough question as to, because people are realize that there's some risk in not being legal guardian, but sometimes it's you want to let them have their say. And the ARC is biggest supporter of supported decision making, which is a way of getting not doing guardianship, but getting some support for these major decisions and documenting that ahead of time, who you want to be on your team to make support. So we're not talking about that today. We're talking about what happens when you have to go to court. So in order to be the guardian, you can't just decide, I want to still be the guardian. Yeah, Kerry, go ahead and move it forward. You need to, hey, yeah. You need to have a judge decide that, because like I said, you're taking some rights away from the person. So in order for a judge to decide that, you need to get clinicians to agree that this is necessary. So it's not up to you, it's up to the professionals who know enough about your child and have done the assessments, etc. So this is why we're talking today about the courts, because you have to go to court. And generally, the issue is when do you go to court because they're about to turn 18? Well, in Middlesex, you can't file before about a month before their 18th birthday, because they view that new Supreme Judicial Court case is saying that you need to be 18 basically to have the hearing and all. Now in Norfolk, you can file at 17 and a half, that kind of thing. But in general, you want to start thinking about this when they turn 17 and start getting your ducks in a row as to what you need to do to file the paperwork, okay? Because it takes some time to get the documents you need. So go ahead, Kerry. So let's talk about the basic, before we get into COVID, we're going to talk about the basic procedure always to get guardianship, okay? You have to file a petition with your probate court of whatever county you live in. Along with that petition, you can't just file the petition without anything else. It has to contain a separate document, which is the clinician's report that says this child needs guardianship. It's either a medical certificate, which is for people with mental illness, or it's a clinical team report, which is supposed to be for people with, only for people with intellectual disabilities, which we generally view as an IQ of 70 or below. The clinical team report requires 3 signatures. So it has to be a medical doctor, a licensed social worker, and a licensed psychologist. The medical certificate only requires 1 signature, but it has to be fresh every time you go do anything with the court. So you need more than 1. Generally, the courts are wanting, if you have autism, your child has autism but is not intellectually disabled, generally you should file a medical certificate rather than a clinical team report. And you also have to file a bond, which is just a form you sign. It's not a big deal. And then once you file that, the probate court dockets it, makes a case, and issues you something called a citation, which sets a deadline by which any objections can be made. It's usually 3 or 4 weeks out, so that anybody, let's say you're divorced and your ex-husband wants to be guardian, he has time to file an objection. Sometimes our children want to file objections, so that's a problem. And that deadline is called the return date on the citation. And before the return date, 14 days before the return date, you have to serve everyone that's involved. The serving means hand it to them to make sure they know about this. And the court needs proof that you've done that, because what good is a time for objections if no one even knows it's filed? So you have to mail it, or you have to give by hand to your child a copy of the petition and the citation 14 days before that deadline. Once the deadline is passed, assuming there's no objections, you call the court yourself for a hearing date. The court doesn't schedule that date automatically. You call them and you can talk to them about what works for you as far as return date, or a hearing date, I'm sorry. Okay, so let's go to the next one. So let's talk about COVID access right now. I mean, court access right now, sorry. So as I mentioned, people are not being allowed into the courts unless unusual circumstances like an evidentiary hearing is required that can't be put off. They're trying to put off, they're not allowing trials at all until September at the earliest. So what do you do to do your guardianship? Well, you go ahead and you put it in the mail. That's the best thing, although it takes them sometimes a while to open the mail and get your citation out. Mail it into your court. You can also, if you're a lawyer, you can e-file it, which I do, or there's a drop box in the court that they allow you to come in to drop your papers in the drop box, which if you're kind of close enough to the court is a good idea, I think. So yeah, that's how you get it started. And then go ahead and go to the next one, Kerry. What happens with the hearing? Well, right now, the judge is determining whether they want it by phone or by Zoom. But most of the judges are doing it by phone. If it's, again, it has to be uncontested to do it by phone. I think in some places, especially in Middlesex, they're only granting temporary guardianships, which will only last 90 days, and then you have to come back for the permanent. And I think the idea is so that you can actually come in person for the permanent. But other courts are allowing full permanent guardianships by telephone. So make sure you wait till after your return date on your citation to call the court for your hearing date, because they don't want to give it before, and also they're wanting to see if they can put it off a little bit so that they can get it in person. Okay, so let's talk about the difference between a clinical team report and a medical certificate. So clinical team report, again, I said has those 3 signatures, and it's really a harder document to prepare and is better evidence for the court. So it should work even if your child doesn't have an IQ of less than 70 and they're autistic. You should be able to file, and usually I can file a clinical team report for those cases. But sometimes courts give me a hard time because it's meant to be for somebody that's intellectually disabled. But the good thing about the clinical team report is that you don't have to do it again. As long as you get that all signed up and filed within 180 days of those signatures, which is a half a year, you're good to go. You don't have to go and get another one. Whereas a medical certificate, which is only 1 signature by a psychologist or a doctor, it has to be within 30 days it has to be filed, and when your hearing, you have to get a new one for your hearing. So it has to be fresh within 30 days. And the reason for the discrepancy is the medical certificate is meant for mental illness that changes, or intellectually disabled. That doesn't change since, Billy was born. It's the same. But the mental illness, the court wants to see that they still need this. So that's the difference. Go ahead, Kerry. So I just want to mention to our population, this is an important wrinkle that you should know about. If your child is the type of child that can access either adult family care services, AFC, or PCA services, and you're planning on doing that, and you're keeping your child at home with you, you can't also be the guardian. You have to have someone else be the guardian so that you can be the caregiver. So if you go ahead and go to court and you're the co-guardian with your husband, and then you decide you want to do these programs, you have to go back to court. It's a bit of a pain. So I want everybody to know about this wrinkle ahead of time. And what I advise people to do is try to talk to people, their providers, to see if they're likely to qualify for the program before they file, so they know whether they need, and it is a very hard thing for divorced families. Divorced families, really, they can't use the AFC or PCA program as their own and be their own caregiver. Sometimes we have families who have an adult children living at home, not away at college, but living at home, that could actually be the caregiver even though you're the guardian. But otherwise, it's a really unfair rule for single parents who are divorced, or not even divorced, just single parents. Is really hard on them. We have been working to change that rule, but we haven't gotten very far on that one. Yeah, so, and then let's say you decide you don't want to be the guardian because of this wrinkle, and then you change your mind later and you do. Well, you have to go all the way back. You have to start all over with a new clinical team report, etc. You have to start all over to become the guardian. This is true. Let's say you want to resign. You're elderly, you're done, you're tired. Your 60-year-old kid wants to take over. They have to start all over again. They have to file the papers and go back to court. Okay, Kerry. So do we need to hire a lawyer to do all this? Well, not necessarily. All the forms are online. What I normally tell people is go to the court, talk to the clerk, get exactly what you need, fill it all out, go back and talk to the clerk again and see what you did wrong, fix it, and file it, because the clerks really do help you. Now, right now, they're not doing that. So, but the good news is, as of Monday, they started this virtual registry program, which is a Zoom call with the registry is really the people at the counter, okay, that help. So those people at the counter are not now available by Zoom, which I think is the coolest thing ever. You hit a button and all of a sudden they show up. Sometimes they don't show up because they're in line, you're in line, but sometimes they actually right there show up and talk to you. So that's what, if you want to try to do this by yourself, you can, by getting some help from the clerks. The lawyer for the day volunteer attorneys are not working right now, so but hopefully once COVID is over, there are people at the courthouse that the clerks will say, hey, go talk to that person, they're the lawyer for the day. They only work a certain day, like Thursdays in Middlesex, Wednesdays in Norfolk, that kind of thing. So that is not really an option right now, but I'm hoping that eventually the Zoom website there's breakout rooms within that they can send you to a lawyer for the day in the Zoom call to help. Now for Rogers guardianships, which I'll talk about, you probably do need a lawyer because it's a little harder. So again, you know, you have to, that one, we'll talk about that. So what do you have to do once you're the guardian? Well, you have to submit a care plan. It's again on that website, a form, 60 days within your appointment, and then every year on the date that you got the guardianship, you have to submit that care plan. It's called annual report. Very easy to fill out. It's fillable. You say, here's what's going on with your kid. Here's where they're living. Here's what's happening. Here's how they're doing. You put it in the mail. You don't have to go to court. And you send it in the mail, and it's put in your file, and you're good to go. So a little harder with Rogers, but that's what happens with regular guardianships. Right now, I understand the courts are behind in processing these care plans. Not Norfolk. Apparently, they're okay, but in Middlesex, they use a Senior Partners for Justice volunteers to process them, and they're not working right now. But anyway, please go ahead and file your reports as usual, even though it's COVID. They'll put it in the file eventually. It's all good. Okay, Kerry, you want to move along? I'm going to check the chat let me just check the chat while I'm talking. Are things basically not moving regarding guardianship in Suffolk County? Last thing they requested was newspaper proof. Okay. Okay, first of all, I'd like to say there is no requirement for newspaper proof in a guardianship unless your family, your ex-husband is parts unknown. Okay, and you can't find him, no one needs to put anything in the newspaper for guardianship. So I don't know what Suffolk is saying. Suffolk is always difficult. So my husband submitted that months ago before COVID. So I guess he already submitted the newspaper proof. So maybe there's, in this case, somebody with parts unknown. Still no notice and no court date. Okay, so you need to call them. And I'm sorry to say that you need to stay on the phone and wait. You're not going to get anything from them unless you call them. So Suffolk is a tough jurisdiction. By the way, if you're getting anxious, tell them. Say, look, they're going to prioritize people that are getting upset. So tell them we have a gap here. We're getting concerned, or we have a health issue, whatever it is. They will take that into account. So they are trying to process these, and particularly trying to process those that people think are closer to a real emergency. Okay, next question. Should a clinical team report be warranted for autism, no ID, when the individual has a Rogers guardianship as well? Well, so the Rogers guardianship, which I'm sorry I haven't really talked about yet. Let me talk about that. That's based on a case in Massachusetts of Rogers, which requires the court to keep special tabs over someone who's on antipsychotic medication. So if your child is taking anything like Risperdal or Abilify or any other antipsychotic med, you have to be harder, because what you have to do is check that box on your petition, and then the court hires someone to represent your child in the guardianship proceeding. The court pays for it, you don't pay for that. But they're called Rogers Counsel, and Rogers Counsel is required to come meet with your child and file a report, or actually, and hopefully actually even attend the hearing and tell the court whether they agree that this child should be taking this antipsychotic meds and whether the dosage seems right and all. And the way I understand it is they don't want somebody like in a group home being over-medicated and left in the corner so they're not in any trouble by giving them these antipsychotic meds they don't really need, or too much of them or whatever. So the court monitors it. So I've heard some trouble with Rogers Counsel not visiting these kids during COVID, but they're always slow to visit the kids. So I don't really know if it's COVID or if it's just normal. You know, these Rogers Counsels, you have to treat them really nicely because they're not paid much and they don't put you on the top of the pile. They have a lot to do. So they don't show up like you'd like them to often. Sometimes they do. You find a really good one. They're like, hey, I'd like to go see the client. Great. But I don't know, but I do know that the court is allowing the clinicians to meet by Zoom to sign the medical certificate and the clinical team report. So I believe that they're allowing the Rogers Counsel to also meet by Zoom, but I don't know that for sure. So then you have to go to court with this Rogers Counsel. Assuming your Rogers Counsel is not objecting to the antipsychotic, you have to file a treatment plan, and then every year you have to go back to the doctor to make sure that the treatment is still correct and file a report. You know, you are also not just the guardian, but you're also the Rogers monitor in most cases with parents. So the Rogers monitor has more reporting requirements. They have to go back to the doctor every year, get them to sign a piece of paper on the treatment plan, and again, you file it, you send it in. Okay, so I think the question was, can we use a clinical team report for someone who doesn't have intellectual disability if it's a Rogers case? So the fact that it's a Rogers case doesn't change whether you can use a clinical team report or not, okay? But my opinion, and Middlesex agrees with me on this one, you can use this clinical team report for a non-ID kid because it's actually more thorough than a medical certificate. Now, some other courts don't agree on that. So it's a little risky to go out there and get a whole clinical team report and then have them tell you, well, I need a medical certificate. I'm not going to take this because there's no intellectual disability. So sorry that it's not consistent. Let me see what other chats there are. Okay, my son's guardianship file was lost in 2019 by the Essex Probate Court. The judge signed off on the extension but stated new paperwork would have to be filed. Huh. Okay, I don't understand how it could be lost. It has to be at least on the Mass Courts e-file system, right? Where, like as a lawyer, I can look up all cases and see what's there, and the paperwork is also submitted on that system. So maybe if you could email me, I will look it up for you and see if I can find the paperwork. I wonder how this could have happened. I assume that at least you have some of the paperwork, right? So no, I don't think you should have to start all over when they've lost the paperwork. So let's see what we can put together as far as paperwork so that we prevent that. You're told there's no requirement for newspaper, but told to do it or they won't move, thanks. Okay, yeah, well, So, okay, what we're learning from this webinar is each court, not just each court, but every clerk is a little different on how they handle things. And we just need to do what we have to do to get it done. So I'd rather not fight with them about it. I'd rather just say, I say, look, I don't think that's required. Try to talk to them, but then just do it maybe, you know? So I don't know. I don't understand what happened there. Okay, new question. The Mass Developmental Disabilities Council worked with numerous stakeholders, lawyers, that are in creating a pamphlet that includes resources and a guide on what to do if you or a loved one are experiencing challenges with a guardian. Okay, good. So that's good to know. Challenges with the guardian. So basically, I want to encourage my guardians to work with their children, work with their, call them wards, and make sure that they're doing what's taking their desires into account in addition to their interests. It's really always a big issue with the elderly. You know, we think, oh no, mom, you can't do that. It's not safe. And mom wants to do that. And then what do you do? So, you know, you have to work with them and try to talk to them and, you know, give them a little wiggle room, in my opinion, when you can. Okay. So let's see if I finish this Rogers thing. Okay, Kerry, go ahead on the next slide. I'm not sure where we are, if we're done. Yep, okay. So that's the situation right now. There's one other thing I wanted to mention is that normally at the hearing you provide your evidence that you served your citation and petition, and the courts will not hear your case unless you have that evidence. It's the second page of the citation that they send you. It's called Citation Giving Notice of Petition for Appointment of Guardian. Huh. Well, okay, that's the headline, but then it's called Return of Service underneath that. So it's a piece of page 2 of the citation. Since we're doing these by telephone, generally the courts are wanting us to mail in that return of service before they'll even schedule the hearing. So they need to have that document. Like I said, they will not hear the case if they don't have proof that you served the right people. So, and the right people in our cases often is the siblings of our children and the other parents. Okay, so please keep a copy of your return of service because things get lost, but put it in the mail so they have it in the file and they can hear your case. Okay, so is there any other questions?
Yeah, I don't see any questions in the chat box. I'll give everybody a minute or so, but appreciate Karen, your detailed presentation today. Just so many things, you know, there's no book that really shows you this is the way you do it during COVID. So, you know, I appreciate your experience in the courtrooms and that sort of thing, and being able to know how to tweak and know what your rights are in terms of being able to file for guardianship, which is awesome.
Okay.
So let's see, I think we got a chat. Yep, a couple of them. Nalada, thank you so much for the webinar, much appreciated. And Celia was wondering, why do you have to go to court if you want tubal ligation?
So I assume Celia is under guardianship, Kerry?
I don't know. Celia, are you
Yes.
do you have a guardian?
Yeah, my mom.
Okay.
So I didn't actually know that. Am I correct that your mom doesn't want you to have it?
No, we both do, but since you're under since I'm under guardian, we have to go to court to get it, which I think is ridiculous.
Well, there are some things the courts want to be involved with. There's some serious medical issues that they want to monitor. I think that's why.
I have autism. I have a wonderful boyfriend. He has CP, and neither one of us want to pass our genetics on to the next generation.
But Celia, I don't think it'll be hard for you to go to court. I think you'll file something and the judge will be
What? Okay.
so, you know, I think it's good that our cards stay involved to some extent because not everybody has such a good guardian as you that loves them and, you know, and so we don't want to do things like that to people.
But it's still a little ridiculous.
But what if your guardian was some stranger?
True. But myself and Mom have decided this is what we want to do. But
I know. But so the laws are for the most difficult cases, not for the easy cases. And they don't want to treat people differently. So I think that there's some laws to really protect our population that are.
Yeah, I'm aware of that, Karen.
Yeah, yeah.
But of all the things, civilization, we have to go to court for that.
Well, we have a history of Nazis, right?
Anyways, okay. All right. We do have another question from Jossie. My mom had my power of attorney, which gave her the ability to advocate for me, but I had full rights.
Right, that's correct. The power of attorney doesn't take away your rights at all. Generally, a power of attorney, we have two different documents in our state, a health care proxy and a power of attorney. We all need one. If we're not under guardianship, we all need those. I have them. I appoint my husband as my power of attorney and my healthcare proxy to have someone able to speak for me if I lack capacity to speak for myself. But I can withdraw that at any point. I could say, forget it. I could sit in the doctor's office, even though I have a healthcare proxy that appoints my husband, and say, nope, he's not allowed in the building. And so it's very much up to me and what I want. It's really meant to be when you're lacking in ability to even understand the questions, speak, and that kind of thing. Who can take over? Who can pay the bills when you're in a coma? That kind of thing.
So what would you recommend between guardianship and power of attorney? How should people make that decision, whether they should do one or the other?
That's always a good question, right? So it's really a hard one in some circumstances. If you feel like you have capacity to make decisions and you can talk to people and get their input and don't need someone else to decide for you, then generally we don't want you to have someone be your guardian. But we have parents who are concerned about their children's judgment and could do something like run off and get married to someone that's trying to take advantage of their money or something like that, or that the kid could be in a terrible car accident and not able to give consent and do something that the doctors need to do. And so in those cases, we do recommend guardianship. But what I would recommend is you talk to your doctor about it, because it really shouldn't be a decision of the lawyer or the parent. It should be the decision of the clinicians that understand capacity issues.
Okay, thank you, Karen. And Jean had a question. I have sometimes heard that someone who is under guardianship does not have the right to vote. However, my understanding is that unless that right was explicitly taken away during the guardianship process in the decree, the individual is able to vote. Can you please confirm?
Carrie, that's certainly my impression. Do you have a different one?
No, I have the same one.
Yeah, we did some research with the ARC of the United States on this and conferred with Fred Misselow, Attorney Fred Misselow, and he also conferred that unless it's explicitly taken away during the guardianship process, the people do have the right to vote.
Right.
All right. Okay. Any other questions?
Can I just get a clarification on that and maybe just share my experience? Because we have two daughters. One, we're in the process of hopefully finishing up. And with our first daughter, when we had the hearing for guardianship, the judge herself asked my daughter, does she want to still vote? And then wrote it into the guardianship decree. So from that, it just seemed to me that she was not going to have the right. But maybe I'm mistaken, but that's how it happened at her guardianship hearing.
Yeah,
and the judge-
that's part of that Exhibit A we had, that where you can list all the things they're still able to do, and the right to vote is one of the things you check. But it's not, it doesn't mean that you don't have that right if you don't check it.
Okay, so for our second daughter, we wouldn't have to specifically ask for her to have the right. It would just be assumed that she could, even
Correct.
if the judge didn't write it in like she did for our first.
Correct.
Okay, thank you.
Those are great questions, especially for those next few months with voting. So essential that we get everybody out there. All right. Anything else, or are we all set? I think that's it. Well, Karen, thank you so much. I really appreciate the time and your expertise, and it's so great to have somebody knowledgeable like you to be able to answer all these questions, especially
Anytime,
during
Carrie.
this.
No, anytime.
Okay, terrific. And
All right,
I hope
take care.
everybody has a great day. I'll be sending a PDF of the slides today. And this has also been recorded, so in a couple of days it will be on our YouTube channel in case you missed it. So anyways, okay, thanks everyone. Have a great day and stay well.
Take care. Bye-bye.
Thank you.